I never learned this in school. So there we have the fee simple absolute. Like I said, if they had named the air, if they had done anything to signify who the air was, it would have lessened this state and it would have become a life estate. Now when you come to a life estate, you have problems because there are things that apply to it. You have responsibilities. To continue on with the fee simple, you'll notice on page 8 I have a few things underlined, such as if, now we're discussing the heirs and or the parties of the estate, and if he dies intestate without any heirs, lineal or collateral, the property escheated to the overlord in feudal days, and now would escheat to the state. The estate, B's estate, will last only as long as he has heirs. Therefore, we have the 14th Amendment getting rid of the heirs. The estate lasts only as long as there are heirs. That is why we hear from these offside roots that the preamble or the Constitution is outdated and outmoded. Yes, because they have gotten rid of the heirs and it is not valid anymore. Why should we keep it around? Let's get rid of it. I heard by word of mouth, I don't keep up with these things, that one of the people who ran for presidency last time wanted to have a constitutional convention. Well, if the throne has been abdicated, a constitutional convention is proper so that the throne can descend to something or someone else. Because we no longer need the Constitution as it is. It's outdated, isn't it? Well, you might think so, but I don't. On page 34, we come to a thing You will notice that I have put some writing up at the top. It says restraint on alienation. Okay, case 40. A being, the fee simple owner of Blackacre, executed his deed to B as grantee in the following words. I hereby grant Blackacre to B and his heirs, but upon the express condition that it shall not be competent for B to dispose of or alienate said Blackacre for a period of 5 years after he receives the title of such property. Okay, so someone's attempting to pass a fee simple absolute here with a big but. But he can't do this or that or the other. So what type of estate does he really have? And down there you'll see the answer is C has a fee simple absolute in Blackacre. This question does not involve either a determinal fee simple or a fee simple on conditions subsequent, for no intention appears on the face of the deed. Here is a fee simple estate vested in B. The grantor then attempts to impose upon the grantee, B, a restraint on his power to alienate or dispose of the fee simple estate. Is such restraint valid? The answer is an unequivocal no. You have no power, no right to restrain a fee simple absolute in any way, shape, or form. You can put no conditions on it. Restraint on alienation. Pigeonhole that word. Because at this time, your Social Security number is a restraint on alienation to that estate. Okay, let's see.
What page are you on, Bunny?
I am now on page 79. We're going into freehold estates still. An estate of freehold is an estate of indeterminate duration other than an estate at will or by sufferance. Again, it says so, indeterminate duration. This is what makes the Constitution infinite, to last for all ages, for all societies. Okay, this makes it immortal. It's beautiful. It is an immortal thing. It's there. Life estates. Now, I should have something on life estates in here. I know they're there. I hope we get to them. But we're going to throw something in on life estates. When you get to life estates, we have conditions on estates, okay? You can no longer waste. In a freehold estate, the fee simple absolute, the heir or the posterity, the person who has the estate, they can waste any portion of it they want. They can burn it, shred it, throw it away, give it away, anything they want. That's waste, okay? That owner can waste. But when it comes to a life estate, no. There is no wasting in life estates. No wasting in life estates. You're subject to duties, regulations, and laws. Wonder what kind of estate the 14th Amendment is. Here's a good one.
What page are you on, Bunny?
We're still on, we're on page 80. Some of the authorities, this is the third paragraph down, in an attempt to exactitude. I'm not always good at reading. Okay. Have employed the term fee simple absolute in such a case or in such a way as to set it off as a distinct legal concept. Totally new concept. Thus, it has been stated that an estate in fee simple absolute means a perfect title. It is the entire and absolute interest and property in the land. Interest in the land. Your rights and duties to it are an interest in that. You have no duties, though, in a fee simple absolute, so your privileges, immunities, or everything is an interest in the estate. Difficult to pay. Page 81, second sentence, there can be only one estate in fee simple to a particular tract of land. It is an estate of inheritance unlimited in duration, descendable to all the heirs of the owner alike to the remotest generations. And aside from the fact that it may be created so as to be defeasible and subject to executory limitations, or granted or devised subject to a condition subsequent, it is with respect to its duration and enjoyment as an interest in property clear of any qualification or condition. It has been defined as an estate of perpetuity, confining an unlimited power of alienation, that or than which no person is capable of having a greater interest. And down at the bottom in the footnote, you will see that an estate which must be a fee simple is absolute, complete, and self-sufficient. An estate which must be nourished or kept alive by the grantee is obviously conditional or qualified or limited. This element of insecurity implicit in the grant impairs the totality and permanency of the estate, and such an estate is not a fee simple. Insecurity? Are you feeling insecurity with your estate? If we had our estate, we would not be feeling insecure. And insecurity is running rampant in this country amongst people. Heavy insecurities. Not trusting the other person, not trusting your brother, your sister, blaming everything on someone else. He did it. Republicans did it. No, the Democrats did it. No, the Latins did it. The Spanish did it. The Mexicans did it. The black people did it. The white people did it. The Koreans did it. Somebody else did it. Nobody is taking responsibility. They don't know who did it. They have absolutely no idea what's going on. Oh, let's see. Use possession. On page 83 in estates, it brings up the use and possession of property constitutes a gift. Let's see. Oh, we have the metaphysical concept of title. I like that word metaphysical. You know, for a long time I thought metaphysical meant ooh, you know, I didn't understand ooh, you know, until my good friend said metaphysical means thinking, thought process. Okay. I like that word. I can understand thinking. It seems like that's all I ever do.
Well, if you quit, you're in trouble.
Yes, I believe so. I'm passing on to more pages. Okay, exception to the rule, reservation of the grantor. Ah, here, we must understand exceptions. Okay, on page 90, the common law rule requiring words of inheritance in a conveyance to pass a fee simple was subject to many well-established exceptions. Thus, although it was usually held that words of inheritance were necessary to establish a fee in a grant containing a reservation in favor of the grantor, because a reservation is technically speaking a regrant of the property, no words of inheritance were necessary to establish an exception in fee simple in favor of the grantor, since an exception excluded from a conveyance that which would otherwise pass. Now, in the Constitution, the Fifth Amendment and certain things are exceptions. That power that was reserved to the people is an exception. Okay, now exceptions are very important when it comes to the estate. Okay, even though they put words of inheritance in here, okay, there is still found exceptions in the body of the Constitution outside of here. And we must find those exceptions at times. In the Fifth Amendment, you were reserved. This is, by the way, this is where liberty is in the Fifth Amendment. I had a couple pages of index on the Constitution, what is found where. Liberty is only found in the Fifth Amendment. That was interesting. The let's see, the blessings, where is it? There, nowhere in the Constitution is found domestic tranquility. There is no corporate power to administrate domestic tranquility. Yet it's in the preamble. It's part of the estate. It's supposed to exist. Obviously, we're not getting our domestic tranquility these days, but yet it is part of the estate and is not listed anywhere or even under any subject of the remainder of the Constitution. And liberty is only found in the Fifth Amendment. Now, the common defense and everything, all these other words, common defense, general welfare, that is enormous, and that is what they're administrating under the corporate mortmain jurisdiction. But several of these things just aren't being administrated under corporate function. It's kind of nice to know that they have something they can't administrate. So when I write to them, I'd like to have my domestic tranquility as part of the estate. Now, am I going too slow or too fast for most of you? Am I doing okay? All right. Oh, here's a good one. It's page 91, up at the top. It says, a grant to the government or a subdivision thereof as for the use of the United States forever contains sufficient words to vest an absolute fee simple. Now, I want you to just pigeonhole this idea of a grant to the government. Okay? In the United States, the common law rule requiring words of inheritance in a conveyance to pass a fee simple has never been applied to a conveyance to a trustee. The estate taken by a trustee is measured by the duties he is required to perform. Like the articles. And the exigencies of the trust, and not by the presence or absence of words of inheritance. But yet there they are, still there. Hence, in any particular grant to a trustee of a fee simple title is necessary to the performance of the trust. A fee simple passes even though the word heirs was not used in the conveyance. Contrary rule is obtained in England, however. So the articles are the duties of the trustees in this estate. Supposed to have gold and silver, all those good things, you know, as money. That's a duty of the trustee. Very interesting. Gold and silver is the trust fund, the money, okay? If that's the money in this estate, what is a Federal Reserve note? Who is Federal Reserve note for? Yeah, but that's a name. What's the thing? We're looking for the things that the Constitution creates, not the name. 14th Amendment is another estate.
A foreign estate.
It's a separate estate. It is a life estate. It is an estate created under the estate. If I own a fee simple absolute big chunk of land and I wanted to maintain control of half of it or 3/4 of it, and yet give maybe a quarter, sell a quarter, convey a quarter to someone else, but still get it back, I'd create a different estate, a life estate. You can have that estate until such and such time, then if you die or the conditions aren't met, I get it back. So I create another estate. That's what's happened. Another estate has been created. On page 207, the non-payment of taxes. Ooh, my. Now we're discussing a life tenant here. The mere refusal of the life tenant to pay taxes is not where there has been no actual sale for taxes, a ground for forfeiture of the life estate at the suit of the remainderman. Next underlined portion. Under some statutes, non-payment of taxes by a life tenant is regarded as committing waste, justifying forfeiture of his estate. Well, they're not going to have you forfeit your 14th Amendment estate, so they just put you in jail. You've committed waste, and now you're subject to certain laws and conditions. Okay, as a 14th Amendment citizen, a life tenant, you're committing waste. That's against law. Even in old common law, it was against the law. So you see, we're at the common law, but yet we can't get to the common law. It's a paradox. The common law we want to get to is up here, way up here, but yet we're still at the effect of the common law because it's still hovering over us. They've just diminished our estates and we didn't know about it. Have not been informed. Full disclosure did not take place. If it did, certainly wasn't in my civics class. Now, under life estates, there are remainders. Okay, if I have a home in a life estate, I have to keep that home up in good condition for the remainders, whoever buys it, whoever gets it after me. A frequently stated rule on page 220, a frequently stated rule is that the remainder must be created by the same instrument which creates the life estate. In the ancestor, in order for the rule of Shelley's case to apply. Now, the rule of Shelley's case is long and drawn out, but it's a highly important rule. Under this rule, a will and codicil are considered one and the same instrument. Okay? It has been stated that the limitation to the heirs may be made by a power of appointment contained in the same instrument. So the rule in Shelley's case is important, and I'm not going to go into it because we have right here quite a bit to go through without going into everything I read and learned. Now we're getting to the point of codicil and will. Okay, all of a sudden that has popped up into our little picture. We're not quite sure where it fits, or even if it does fit, it might belong to some other puzzle, so we're going to sit it over here temporarily. And now we come to American Jurisprudence 2D, which is volume 23, Dedication to Desertion and Non-Support. But we're going to be looking up deeds. We're going to find out what a deed is. You see, all of these things that are very important when we're looking at a trust, at a use, we have to look at what is a will, what is a trust, what is a deed, because deeds start coming in, and so do grants, and so that everything can come into proper perspective. Okay, so in deeds, what if I was wrong? What if this was a deed? Actually, it is. Okay, it is a trust. Everything, it all comes in. Up at the top here, grant is a synonym of conveyance. Do you remember back when Mr. Baldwin said it was a grant?
Can you let us know what page you're on?
82.
82.
82.
You missed that one. Remember Mr. Baldwin, the Justice Baldwin said that the Constitution was a grant? I do believe I read that. Right here in deeds, it says, grant is a synonym of conveyance. So now Blackacre has been conveyed. We now know it is a grant. Okay, and we find this under deeds, so obviously it is a trust deed. Doesn't have to be, but it is. This is very flexible, folks, unlike the law we know today. You know, we can take the word deed out and still say this is a trust without the word deed in there. Somebody brings a grant in, okay, it's a grant too. Yes, it's a trust, it's a deed. There are things that it is not, but there are many things that it is. Assignments, Section 5. The term assignment, which signifies the act by which one person transfers to another or causes to vest in another his right of property or interest therein, is sometimes used synonymously with grant. Again, so as to operate as a conveyance of the title to real property. But is ordinarily limited in its application to the transfer of intangible rights, including those in action and rights in or connected with property, as distinguished from the property itself. The term assignment, unlike the term deed, does not signify an instrument under seal, and at common law, if not under seal, it was not sufficient to pass legal title to real property. This document is a document under seal. Oh, then we have mention of wills down at the bottom on page 83. Under deeds in Amjor, we have wills. Okay? Whether an instrument is a deed or a will depends primarily on its operation and not on its form or manner of execution. The essential characteristic of a testamentary interest is that it operates only upon and by reason of the death of the maker. During his lifetime, it is ambulatory and revocable. Hence, the maker, by its execution parts with no right and divests himself of no oh God, this is getting different, modicum. Modicum, how do you pronounce that word? Modicum? Modicum?
Modicum.
Modicum, okay, of his estate. I see, I'm not all-knowing. Even though you might think I am. After you know what I know, you're going to be a know-it-all too. It is fundamental, on the other hand, in order that an instrument may be operative as a deed, that it pass a present interest, although it is not necessary that the grantee take a present estate in the property conveyed accordingly. This is defining deeds and wills. On the operation, what was the primary operation of the Constitution? Besides, the Founding Fathers did not have testamentary capacity. The Statute of Wills says that. But now we're segueing into, we're bringing in a little bit of will stuff because we're going to find out that the 14th Amendment creates a codicil. It is a codicil. The Founding Fathers are obviously dead, folks. They must be dead because everybody is taking under a codicil and looks like a will part of our document. It's segued. They must have died. We're going to find out that the 14th Amendment is you make an election to literally take under a will. Page 90. Deeds are traditionally regarded as consisting of a number of formal parts, the first of which is known as the premise. The premise of a deed, sometimes designated the caption, embrace matters preceding the habendum clause, such as the recitals of the grantor intention and motives for his deed, the names, designations, and descriptions of the parties, etc., etc., the conditions expressed for the deed, words of grant, and the description of the property conveyed. Okay. Yeah, it defines it. Defines the property conveyed. The Constitution appears to have a habendum and all these things that are in deeds. Okay? We're looking at the construction of the instrument. This is how the Supreme Court looks at things. Words of grant on page 91. In order to transfer title, an instrument must contain apt words of grant, which manifest the grantor's intent to make a present conveyance of the land by his deed as distinguished from an intention to convey it at some future time. This showed no desire to do it in a future period of time. This was right then, there, and now.
Always now.
Always now. Oh, and down here in the bottom in section 20, although words of inheritance such as to the and his heirs and assigns forever are no longer necessary to pass a fee simple, the use of such words strengthens the reading of a deed to pass a fee simple title. Okay, so they strengthened even today, and not to amalgamum of lesser states. Addendum, let's see, word covenant. Page 575. This comes from Amjor 2D again. We will find this under covenants. Covenants, conditions, etc. We have a covenant here. There is a covenant sitting right in here. Insure and secure. Those words are words of guarantee, insurance. The term covenant in its wide sense is used to indicate a contract, while the more specific application of the term imports an agreement deduced to writing and duly executed, whereby one or more of the parties named therein engages that a named act is already performed or is to be performed sometime in the future. A covenant may also call for the performance or non-performance of some specified duty, and may constitute an agreement to do or not to do a particular act. Is that in the Constitution?
Yes.
We have a covenant.
That's a moral obligation.
The term covenant is now used primarily in connection with promises, in conveyances or other instruments pertaining to real estate. You know it says now, but not then. Then this was a covenant. Again, a covenant at common law imports an instrument under seal. We have a covenant. Duration of covenant on the next page, 577 of Amjor. A covenant is therefore extinguished when the estate ceases. We are in imminent danger. Wouldn't you say so? This is still on the books. It's still in black and white. It has not openly been repealed. But I have a very sneaking suspicion that our government is going to take our estate away from us on or in black and white, or out of black and white, whatever way you want to say it. We are in imminent danger. We don't know what we have been arguing and fighting for until now. We can now look into the future. Okay, page 584. Let's see, second sentence. A covenant is viewed as implied in nature when its existence is inferred by legal construction from the use of certain words and phrases. Certain words and phrases. Insure and secure. These words are very important because they have a legal meaning. Every word in this document has a legal meaning when it comes to estates and when it comes to the construction of the written instrument itself. All the power of the entire Constitution is right here, not elsewhere. Because this created the corporate function. This created the trust function. This gave all of it power. Page 585, second paragraph, or let's see. Implied covenants can arise and will prevail only where there is no exception on the subject matter of the implied covenant. This is something you should look into at your leisure. Implied covenants still count, even if those words are implied, they count. On the next page, 592. Reflects upon the 14th Amendment, okay, the marked area. At common law, no person may claim the benefit of any covenant or condition except where he is a party or privy thereto. As a 14th Amendment citizen, you are not party or privy there to this estate, so therefore you cannot claim the covenant. You are barred from it. Are you getting to understand why we're having a little frustration in court? We're having a lot of this. Page 594, section 23 of Covenants. The benefit of a covenant that runs with the land descends to the heirs, and they, as well as devisees and covenantees, are entitled to enforce such a covenant unless an evident intention is manifest to confine it to the covenantee. In the event a real covenant is breached, then it descends to the heirs. The latter may institute appropriate legal action to recover damages for such breach. However, if the covenant is personal, it remains with the covenantee or his executor or administrator. It does not descend to the heir. Try to go through this. On page 617 of Covenants and Condition, 20 Am Jur 2D, section 45, breach of covenants generally. The broad rule is that a covenant or condition is broken by any single omission of duty or any act that contravenes the provisions of the agreement entered into between the parties. We have a breach of covenant. This is what we entered into, and it has now been broken by many acts of omission and duties toward this covenant. Not toward the 14th Amendment, but toward this specific one. Page 629, we're discussing paramount titles. This is a paramount title, okay? 14th Amendment citizenship is in the state of inferior title. We're going to find that out. The mere existence of a paramount title which has never been asserted generally does not amount to a constructive eviction. We've got to assert these titles, okay, which will support an action for breach of a general covenant of warranty. Or, as the rule is sometimes stated, there can be no recovery in an action for breach of the covenant if the paramount title has not been hostilely asserted. So we're going to have to hostilely assert our paramount titles. Section 59, where the paramount title is in a governmental entity. Where the paramount outstanding title is in a government, this fact of itself constitutes such a constructive eviction as amounts to a breach of the covenant of warranty. Now, wasn't that nice of them to put that right there in black and white? So they have breached the covenant, they have breached the covenant of warranty, evicting us. We're just going to have to go back and assert our titles again. A grantee by warranty deed executed by a private person to lands owned by the United States cannot take possession without becoming a wrongdoer. Here's your allodial titles. And hence his right of action accrues immediately to recover for a breach of this warranty, and is not dependent on eviction or any future event, but under a statute providing that a warranty in actual possession of the premises conveyed shall have no right of action on a covenant of warranty until the party threatening the warranty's possession shall have commenced an action to obtain possession. We'll stop right there. Okay, so this is all about the breach of warranties in the covenants. Now, the next section is wills, but before I get to that, I want to read a definition out of Webster's 1828 dictionary of fee simple, okay, because the question has arisen that fee was feudal, etc., and that it wasn't an allodial title. Okay. We'll skip some of this. Let's see, it's deduced from Saxon cattle, property, and fee, or primarily a loan of land, an estate in trust. Fee simple absolute, an estate in trust. Granted by a prince or lord to be held by the grantee on condition of personal service or other condition. I'm not too sure what the conditions are on the estate here that we have. And if the grantee or tenant failed to perform the conditions, the land reverted to the lord or donor, called the landlord or the landlord. In America, where lands are not generally held of a superior, a fee or fee simple is an estate in which the owner has the whole property without any condition annexed to the tenure. In the United States, an estate in fee or fee simple is what is called in English law an allodial estate, an estate held by a person in his own right and descendable to the heirs in general. So a fee simple absolute in the United States is allodial title. We're now going to discussion on wills, because like I said, I was looking to find out what was the Constitution, and the question had come up about the question had come up about what was a 1040? Was it a will? And I have to say I don't believe so. But in researching it, I found a lot of interesting things on wills, so we're going to go into that. Pardon me. Okay, page 275 of 79 Amjur 2D on wills. Okay, in there in the second sentence it says, by common law there were but two modes of acquiring title to real estate, namely by descent or by purchase. Where a person takes as heir at law, he takes by descent. But when he takes title to land by his own act or agreement, he is a purchaser. A little confused. Okay. although in common application of the term, he may not have paid a consideration for it. A devisee who takes an estate different from what the law would cast upon him as heir is a purchaser. You can look at the 14th Amendment as being purchased. The estate is purchased because you take something that is other than what would be cast upon you by the law. This is the law. Okay? And as such, under the feudal system, was exempt from the restraints imposed upon heirs in their minority, such as wardships and right of marriage. Although the feudal system had passed away, hardly, I don't think so, many distinctions of this character are still of recognized importance. It certainly is, because it hasn't passed away. It is still in existence, and I look at the world today, and we are living in feudal times. Accordingly, the doctrine of common law, even after the passage of enabling statutes, was that a will was in the nature of a conveyance, declaring the uses, purchase and not by descent. So if your father leaves you something in his will and you take it, you did not inherit it. You purchased it. Legally, you purchased it. You did not inherit. If he did not leave a will and you got his estate, then you inherited it. It fell upon you by descent and distribution. Otherwise, you purchased your estate. Just that simple. Can't get around it. Page 285. The animus testandi does not depend upon an understanding by the testator that he is making a will. Okay, the Founding Fathers created a trust, okay, and it was complete until after the Civil War. Then they start adding amendments. Now, if there is a trust, there's a possibility that the amendments could be construed as codicils to the will, or codicils of a will. It is a trust, and there are such things as wills or trusts with wills attached, or vice versa. Okay, so if we begin to look at the 14th Amendment as a codicil changes the intent of the testator, or the trustor, or whoever created it. 14th Amendment literally did change the intent of this right here. And they didn't have to know they were making a will, as this little paragraph says. The fact that the testator did not intend the language to operate as a codicil is immaterial on the question whether the instrument is in fact a codicil. Okay? So now we're going to start looking at the 14th Amendment as the codicil. Page 297 brings up the idea or thought of an instrument of dual character. Okay? Down toward the bottom it says, an instrument in writing may be a contract respecting property in one part and testamentary in another part in relation to other and distinct property. Here we have a definition and description of this estate as compared to the estate that we're going to see the 14th Amendment create. On page 314, again, section 55 there under wills, it says, property does not pass under a will by any natural right. There go your inherent rights, your vested rights, everything that comes into from the Magna Carta. Okay, so if you're a 14th Amendment citizen, getting all your rights and privileges under a codicil, you do not have any natural rights. Your natural rights reside right here. You've given them all up for the privileges that the government has bestowed upon you. This is a state law. I didn't make this up. In these pages that you have, when you go through them at your leisure, you'll see that I have encircled or bracketed the footnotes. And a lot of these footnotes have some wonderful things to say or to look up that relate back to the paragraphs. So study these intensely. Really get into it, because there's more here than what I'm giving you. And even what I'm giving you, there is a world more. I couldn't include everything in this lecture. Okay, but I figured this is the bare necessities for you to have and understand, and from here you can branch out. And if you get a letter from the whoever, the FTB, the State Board of Equalization, or the IRS, if you stay focused on your estate instead of them sucking you into the regulations that are established under the 14th Amendment for that particular estate, hopefully you will feel much better. Instead of arguing their argument, you will be arguing yours. At least I find that to be of value. If the testator intended to make an entire disposition of his property in substitution of that made by a prior will, he probably would have proceeded to make a new will rather than a codicil. Okay, so that applies to the Constitution. Second paragraph, while a codicil is a latter will in the broad sense, it is not an independent will, but purports by its form to be an addition to a prior will. Okay, so we're looking at the Constitution now and say, okay, the original form was a prior will. Now we're adding the 14th Amendment as a codicil, changing the intent. Several clauses of the two instruments should, if possible, be harmonized so as to give effect to every portion of each instrument. Now we're separating things, okay? We're separating the two estates. They both have to coincide, truly, okay? Because the 14th Amendment is one state, but it comes from this estate. But in our minds, we have to separate them so that we can tell the difference. Okay, and in our separation, they still have to mesh perfectly. That's why there is no conflict of law. Okay, their estate and our estate are in complete agreement. Should be. On the next page, 651, section 532, where codicil is clearly inconsistent with will, where it is found that a will and the codicil thereto contain repugnant bequests of the two bequests, the one contained in the codicil shall stand. That's nauseating, isn't it? A codicil plainly inconsistent with provisions of the will operates to the extent of the inconsistency as a revocation of the will, even in the absence of any expressed words of revocation. Page 663, and this is where it's going to start becoming important to you, okay, to understand that the 14th Amendment as a codicil and what you have done. Section 1607, the doctrine of election. The doctrine of election in connection with testamentary instruments is the principle that one who is given a benefit under a will must choose between accepting such benefit and asserting some other claim he has against the testator's estate or against the property disposed by the will. One who elects to accept a benefit extended to him by a will is bound to give effect to all the provisions of the instrument and perform the burdens imposed upon him therein, including the renunciation of any inconsistent rights or claims. Yes, elections. We look at the 14th Amendment as a codicil. We have all made elections to take under the codicil or take under the will. Okay? Oops. I lost my thing.
I lost that a long time ago.
Okay. Be nice.
Gotta be edited.
Okay, let's go to page 677. About 677, section 1622. Manner and form of election, what constitutes? The question of the manner and form in which an election to take under or against a will must be made, or as it is sometimes phrased, of what constitutes such an election, is influenced to some extent by the applicability or inapplicability of a governing statute relating the particular kind of election election in question. If the election is one governed by statutory provisions relating to the manner or form in which it is to be made, the effect of such provisions must, of course, be considered. In the absence of an applicable statute, however, the view is generally taken that a testamentary election may be expressed or may be implied from the acts or conduct of the beneficiary on whom the election devolves. Second paragraph, there can be, it has been, excuse me guys, I don't mean to be this way. There can, it has been said, be no partial election to take against a will, but the election, when made, must be complete and final. This is saying that you cannot ride the fence. You can't use that Social Security number and have this. You can't have that bank account and have this, at least not at this time. You can't have all those wonderful benefits that are given to you by law and have this. Just can't do it. There's no riding the fence at this time. That's sad but true. Sad but true. Page 679. With respect to elections arising from matters in pays or implied from the acts or conduct of the beneficiary, it may be said that two things are necessary in order that the acts relied upon will amount to an election. Number one, the person alleged to have made an election must have been cognizant of his rights. I'm sorry, I don't mean to laugh. That is, he must have knowledge not only of the condition and event of the testator's estate, but also extent of the testator's estate, but also of his duty to elect between the two inconsistent rights. I don't believe anybody's ever informed me of that. Of course, they always tell me I made an election. And to having knowledge of his rights, he must have intended, as shown by clear and unequivocal acts, to make a choice. Haven't you done that? You've all done that. By your acts, you have seemed to made a clear choice. By your own acts. Of course, you weren't told your rights. You weren't disclosed anything about the estate. In order that the beneficiary's ignorance of his rights may avoid what otherwise could constitute a conclusive election, however, it must not have been culpable on the part of the beneficiary, and the misapprehension must be clearly shown. Okay, if you haven't been informed of your rights and you have had non-disclosures, you better start telling them about that, because it doesn't, your election really is no election. Okay? You might have made an election as it appears to them, but they did non-disclose to you. As a matter of fact, I don't believe I recall my civics class teaching me about this estate. And in my history class, I don't recall hearing about it either. Of course, I always heard that the government agents and the bureaucrats were, what do you call it, trustees or in their fiduciary capacity. You know, we've all heard that. Of course, they didn't explain that to me. And as an heir, I believe I have the right to know what they mean by their little words. They are trustees. Page 681. Section 1626, acceptance of money or property. In a large number of cases, the principle is is recognized, stated, or applied that a showing that the beneficiary faced with an election for or against a will has accepted, used, enjoyed, or entered upon, or remained in the possession of money, yes, like Federal Reserve notes, property, or some other benefit, like unemployment, extended him by the will, tends to establish an election in favor of the will. The rule is, of course, subject to the qualification that acceptance of a benefit under a will, when made in ignorance of the beneficiary's rights, or under a misapprehension as to the condition of the testator's estate, such as bankruptcy, or other pertinent factual considerations, does not operate to constitute an election. Hallelujah, hallelujah. Okay, did you notice there? It said ignorance of your rights. Remember that little comment that ignorance of the law is no excuse? Well, ignorance of your rights is no election. How do you like those apples? I thought that was good. I like that. Moreover, the principle is subject to the further limitation that where the money or property was received or accepted in some other capacity than that of a testamentary beneficiary, well, maybe it's not. Maybe we're not testamentary beneficiaries. Maybe we're heirs. Okay? Or amounted to no more than what the beneficiary would have been entitled to, independently of the will. Such receipt or acceptance does not indicate the making of a binding election in favor of the will. We're entitled to it to begin with.
As heirs.
As heirs, we are entitled to it. Those people who are taking under the will, who don't want to be heirs, but want to be beneficiaries of a different estate in order to be taken care of, because they're not capable of taking care of themselves and be independent, they may do so. I'm not going to stop them. I just want my freedom. I want my inheritance. I want my estate, that which was guaranteed to me. On the next page, you'll see some footnotes that are bracketed. Take a chance to read, or time to read those when you have a chance. Okay, Section 1630, initiation or maintenance of judicial or administrative proceedings. Okay, while there is a general agreement that the unsuccessful assertion, and we've had plenty of them, in a judicial or administrative proceeding of a claim under or against the will does not amount to a conclusive election for or against it, the theory being that where such a claim is proved groundless, it is conclusively shown that the beneficiary was not in possession of two inconsistent rights. Oh, we're commingling. And hence was under no duty to make an election. There is no doubt that prosecution of or intervention in the judicial or administrative proceedings will, under many circumstances, be regarded as constituting an election to accept or renounce the provisions of a will. Okay, so what if you use the district court? Now you go, well, what does that mean? Okay, well, the district court is a tribunal established under the inferior estate of the 14th Amendment. And just because you've gone there doesn't constitute an election. Page 687, section 1634. As a general rule, an unconditional voluntary election to take under or against a will made with knowledge of the facts and of the rights of the person compelled to elect, and not induced by fraud or undue influence, may not be revoked or set aside.
I was told I had to get a Social Security number in order to work.
I believe that you've had a little bit of non-disclosure to it. Well, they're presuming that you were party to an inferior estate, one created for your benefit, because it is presumed that you are incompetent. Okay, next page, 1636. The prevailing rule is that an election to take under or against a will may be revoked or set aside where it was made through ignorance or mistake as to material facts affecting the rights of the party electing, and where the rights of the innocent third party will not be adversely affected by the revocation. I wonder who that might be. The revocability absent intervening rights of innocent third persons, the elections procured through fraud or undue influence, or of elections followed by the failure of the provision made in the will for the electing party, or the non-performance of a condition upon the election was made, has been widely recognized. I believe there's a condition. All of this applies. It all applies, okay? When we have to look at the 14th Amendment as a codicil. Next page, section 1639. In this paragraph, you are told that if by some slight chance, or even a big chance, you have taken property under the will, you have to return it in good faith. You got to return it. You have to offer to return it. But it's just proper to make a good faith offer to return it. This isn't everything. Okay, now we go section 1647 on page 700. The broad principle that one who receives a benefit, and Social Security is a benefit, so is unemployment, so are your schools. When you read the statute of charitable uses, you will find what your benefits are. I mean, it's schools, it's military, it's highways, it's everything. All these things are benefits, okay? And all these things are received under the 14th Amendment estate. The broad principle that one who receives a benefit under a will by which the testator attempts to dispose of property which belongs to the beneficiary, or in which the latter has some right, claim, or interest, must, whether or not the testator was aware of his own lack of complete ownership, elect between his right to accept the provisions in the will in his favor and his right to assert his independent paramount title. We're now asserting our independent paramount titles, which is recognized in many decisions, has received actual application in a wide variety of factual situations. Prominent among these may be mentioned the situation existing where a testamentary beneficiary is the obligee in an alleged contract of the testator to devise or bequeath property, where a device or legatee is also named as beneficiary. And we can stop there. Contract, contract, is this bringing in some commercial UCC stuff? Contract? Did we enter into a contract in the 14th Amendment to receive benefits? Now, there might be a possibility there. Yes, I think so. Yes. So therefore we become an obligee. Now we have a possibility of the UCC coming in, so we keep that right here. 1657. Estoppel. Estoppel means you are stopped. You are barred. Now that means a little bit more than that, but just...
Which one?
Section 1657, page 712. Okay. we're bringing in the bar to us getting to the estate. The broad doctrine that one who accepts benefits under a will is subject to certain exceptions and qualifications. Estoppel to attack its validity and binding effect is frequently recognized. You go into and you start talking about your rights and etc. under the 14th Amendment. You are estopped. You can't get to your rights. You have no rights. They are privileges. Your rights reside in the preamble. Okay, you have created an estoppel by taking under the will.
Light went on.
Oh, did we have a light bulb go on? Oh my God! Have any of you had light bulbs go on? Any of you have a like a flashlight going? Wow! I hope so. I hope so. That's what this is here for. Okay, claim acceptance of money. Okay, what am I going to read here? The view is sometimes taken, for example, that an election to take under a will once made itself operates as an estoppel. Okay, again, estoppel. You elected under the Social Security. No wonder you can't get rid of your Social Security. Okay, all those little revocations and letters to the Social Security Department, and the Social Security Department's going, hey, no, man, your Social Security number. You can do anything you want, And you try to get rid of that Social Security number, and you feel like you can't, but, you keep trying. Well, you're stopped. You took under the will. But then, of course, we haven't attacked in this angle before. Okay, when I recently sent a nice little letter to the Social Security Department informing them of their restraint on alienation, bringing up trusts in the states. And I don't think anybody has discussed this with them before. So we're going to try a new angle here. And we're going to keep trying to get new angles until everybody understands what's going on in this country. Then we won't have to use any angles because we will have our power back. The United States, the people of the United States, the voting citizenry, are getting so angry that they're all claiming that they're going to get their country back. They have no country to get back. They have no inherent rights. I'm sorry. It's that simple. It's sad but true. Let's continue on. We're getting out of wills, and now we're going to go to descent and distribution, which is found in Amjur 2, or I found in Amjur 2D, 23, or 23 Amjur 2D. Section 2, it's page 756. Descent and distribution, section 2, second paragraph. In its strict technical sense, the word inherit means to take as an heir, at law, by descent. Within this meaning, personal property is not inheritable. Oh, there's a hole there. One who takes under a will does not inherit. You take under the 14th Amendment, you do not inherit. This is an inherent right. It says so right here under estates, wills. They all fall together. Here we have something about vested at birth. We have to get to understand what vested rights, inherent rights, inherited rights, these all come together. The United States people as a conglomerate have no inherent rights. They have no vested rights. Well, they have vested rights under the 14th Amendment, but no vested rights here. And well, we have to keep this very perfectly clear. Let's find the next beautiful paragraph. Now, you have to also remember, too, that the 14th Amendment was never legally ratified because the 11 southern states were kicked out of their legislators and replaced with military leaders. So that nullified the Constitution at that point, and everything since then is obliterated. It is not law. It might be law for an inferior state, but not for us. Actually, I guess we have no law. Oh, let's go to a sideways page. When I write now, I don't call myself a state citizen because I don't like that word anymore. when I look at the 14th Amendment, and I know that the United States government has the authority to do whatever it wants in its corporate capacity to property that has been owned or is owned to and ceded to them or granted to them, I look at the 14th Amendment and I say, this looks like a grant to me. It looks like property ceded to me. As much as I don't like the idea that sovereign state citizenship has been ceded to the United States government, it may be a possibility. And if it is a possibility, what do I have left to discuss with them about where my rights come from? Well, I have my estate, and I also have the idea that I am an heir of freedom, as the Founding Fathers were. That's what they claimed themselves to be. They didn't claim themselves to be sovereign citizens. They didn't exist. The Crown gave that to us. So if sovereign state citizenship has been ceded to the United States, such as what we find under the Buck Act, okay, totally different subject, but it's also an interesting theory that the state has been ceded to the federal government. So now what do I discuss? Well, I discuss my heirness. You can call it, I am an heir, okay? And on this page here, I call myself an heiress astrarius, which is a common law word. And let's see if we can find it. Okay, down here there's 2 stars on the left, and it starts out with Coke shows. Okay. Coke shows the heir apparent may also be complete heir. That's me. And have use and profits of the estate. Yes, 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 that's me. That's me. That's definitely me. He is termed the heiress astrarius, and he takes by descent. For if he took by purchase, he would be subject to relief, and I am definitely not subject to relief. I have no relief, so I must be the heiress astrarius. So therefore, I now sign my name, comma, sui juris heiress astrarius, because I'm also of age and I am competent. And this is the dawning of the age of Astrarius. This is, yes. Okay. I think they've already done that, except they really messed up the wording, so they probably couldn't read when they wrote the song or sang the song. Okay, now so far we have gone through the most important thing to understanding the preamble. Okay, the estates, the covenants, the things, and like I said, in your leisure, I mean, right here, I've just skimmed over this right here. You have plenty of material to read from what I have just given you, and there's more of it. Okay, now we're going to go into trusts, okay, because we're going to segue from our state over to the inferior estate. Okay, everything I read will still apply to this, but now we're going to start swinging over here to the 14th Amendment, and we're going to look at a different estate.